The initial findings of the Supreme Court appointed panel have, it seems, given a lifeline to stocks of Adani Group companies, which continued their upward march on May 23rd. In the preceding 3 days, the stock of the group's flagship company, Adani Enterprises, shot up 38%. It has not just recouped all of the losses it made since late January, but even turned a multi-bagger. In its January 24th report, short seller Hindenburg alleged that the Adani Group had engaged in what it called a brazen stock manipulation and accounting fraud scheme. It also accused members of the Adani family of creating and managing what it described as a vast labyrinth of offshore shell entities in several tax havens. The report claimed that some of these entities were used for market manipulation. It also identified 38 Mauritius-based entities allegedly controlled by Vinod Adani, the elder brother of Adani Group chairman Gautam Adani, and his close associates. The Adani Group has refuted Hindenburg's allegations in a detailed 413-page response. An expert committee was later formed by the Apex Court to look into regulatory issues. In its initial findings, the panel said that there has been no regulatory failure on Sebi's part with regard to Hindenburg's allegations against Adani of violation of minimum public shareholding, non-disclosure of related party transactions, and price manipulation in its stocks. But this doesn't necessarily mean that the group has received a clean chit. As a Business Standard columnist put it, there are facts about the Adani stocks that remain smelly, despite an apparent clean chit from the committee. This brings us to Sebi. On May 17th, the Supreme Court granted the markets regulator a 3-month extension until August 14th to submit its probe report into Hindenburg's allegations against the Adani Group. While Sebi was to submit its report by May 2nd, it had asked for an additional 6 months, citing the complexity of the case. Sebi has also said that the allegations that it had been investigating the Adani Group since 2016 were factually baseless. Sebi has said that it has been probing alleged violations of the minimum public shareholding norms by the Adani Group since October 2020. But Sebi has its task cut out for it. As Bloomberg columnist Andy Mukherjee explains, after a 2019 rule tweak by Sebi, it is no longer necessary for a foreign fund to be able to disclose every ultimate natural person at the end of the chain of every owner. Thus, Sebi may never be able to prove anything, even if the Adani Group has violated the minimum 25% public shareholding norm. According to Mukherjee, Sebi is unlikely to find success while probing the alleged non-disclosure of related party transactions too. Sebi has picked 12 transactions for closer examination from among the charges made by Hindenburg against Adani. So, what can be the expected outcome of the Sebi probe? One of the aspects being investigated by Sebi is whether there has been a violation of rules related to maintaining public shareholding of at least 25%. The suspicion raised is that entities linked to Vinod Adani had bought shares in a number of Adani entities, leading to a breach of the minimum public shareholding rules. An emailed query seeking a response from the Adani Group on the SC Expert Committee's report and allegations against Vinod Adani was unanswered till the time of filing of this report.
Now, the question is that the shareholding which is declared in the public domain is maybe in the name of X, Y, Z, whatever it may be. Now, that itself is not suffice for coming to a conclusion whether there is a violation of public norm or not, unless until I can trace that shareholding back to Adani or Adani family. Now, then comes the problem that all these shareholders who are resident outside India are either in a tax haven country or the countries in which we do not have a reciprocity arrangement. That is one. Even if there is a reciprocity arrangement, what happens when you cross the first step, then you go to next. So say, for example, there are 10 layers in a holding structure. Now, I go for company one. When I go to company one, then I find that the parent of this company is 3 different entities which are in 3 different locations. I will have to then go back to those 3 locations. Then in that 3 locations, if I find that company which was first intermediary is owned by 5 people in 5 different locations. So what happens? This complexity keeps on increasing. And since you are dependent on a third party to give you a document or give you research or give you bank statement, you cannot go like a Indian Sebi and say to a company XYZ that I want this data tomorrow. Sebi does not have that power to seek data in a time-bound manner.
The other aspect SEBI is investigating is whether there was any manipulation of stock prices in contravention of existing laws.
To find conclusive evidence of share price manipulation and similar issues is a difficult task, and not only in India, across the world, you must find cogent evidence which proves beyond reasonable doubt, like as if in a criminal trial, that there was a stock price manipulation and that was done by A or B or C.
So, what's next in SEBI's Adani probe? A multitude of challenges, because of which experts are not very optimistic about SEBI being able to get to the bottom of Hindenburg's allegations. Ultimately, this could mean that the haze of suspicion surrounding the Adani Group could persist.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.